Imagine this. You're a judge, murder trial, robbery trial, and you've got a confession right there on paper, made before a magistrate. Looks official.
Seems straightforward enough initially.
But then you hear the evidence. The accused claim they were forced, maybe threatened, and you, the judge, you and your assessors, you listen and think, I'm not convinced. I actually have a reasonable doubt this was voluntary.
Yeah, that little voice of doubt.
Exactly. But then there's this old law, Section 217, right? And it says, nope, reasonable doubt isn't enough. The accused has to prove, really prove they were coerced.
Not just raise the doubt, but actually prove the contrary.
And the judge in this real case basically said, look, if this old law stands, these guys might walk free, even though they kind of confessed in court during the hearing about the confession. But, well, that might just be the effect of the new Constitution. Chillin', right?
It really sets the stage, doesn't it? The tension is palpable.
Welcome, everyone, to another deep dive. Today, we are plunging headfirst into a truly pivotal moment in legal history, the South African Constitutional Court case, SV Zuma and Others. This was heard back in 1995.
A really foundational case.
Absolutely.
Yeah.
It wasn't just, another appeal. It was a fundamental test for a brand new democracy figuring out how to square old laws with these powerful new constitutional rights.
That transition period is always fascinating legally.
So, our mission today, we're going to unpack this crucial decision. It fundamentally changed criminal procedure, especially around confessions, and maybe even more importantly, it laid down some core principles of South African constitutional law that are still vital today. And this deep dive is for you, whether you're deep in law school or just, curious about how justice systems actually work and evolve.
And what's so fascinating here, I think, is how this seemingly technical rule, who has to prove what about a confession, became this huge symbolic test for the new South Africa.
Right.
It's that classic clash, isn't it? The state wanting to prosecute crime effectively versus the absolute need to protect individual rights and liberties. This case really drew a line.
Okay, let's dig in. To really get the Zuma case, we first need to understand the piece of law right at its center. Section 217 of the Criminal Procedure Act, the one from 1977.
The main player in this drama.
So traditionally, and this goes way back, like centuries, based on English law, for a confession to even get into court, the prosecution had to prove it.
Prove it was, and this is the classic phrasing, freely and voluntarily made, in his sound and sober senses and without having been unduly influenced.
That principle was solid in South Africa since, 1830. And there was another layer added in 1917 confessions to most police officers, generally inadmissible. Unless they were confirmed, written down, in front of a magistrate or a justice of the peace.
Yeah.
The idea was, a more neutral setting, less pressure.
Makes sense. Bit of a safeguard.
But here's where it gets really sticky, and this is the bit that got challenged. Proviso to Section 217.1.
Yes, the infamous proviso.
Introduced in 77, and basically flipped the script. If a confession was made to or confirmed by a magistrate and written down, then Section 217 presumed it was freely and voluntarily made.
Presumed. That's the key word.
Exactly. And the killer phrase was, unless the contrary is proved.
And that little phrase, unless the contrary is proved, is, everything. It shifted the entire legal burden, the onus, we call it.
Right.
So instead of the state proving, yes, this was voluntary, the accused suddenly had to prove, no, it wasn't. And not just raise a doubt, remember. They had to prove it on a balance of probabilities.
Meaning, more likely than not.
Exactly. Think 51% likely it wasn't voluntary. If it was just 50-50, evenly balanced. The presumption stood, the confession was in.
Wow.
That's what lawyers call a reverse onus clause. And deciding whether evidence like this gets in, that usually happens in what's called a trial within a trial, or a voir dire in some places. It's like a mini hearing just on that specific point.
Okay, so let's zoom in on the Zuma case itself. What actually happened?
Well, you had two accused, charged with 2 counts of murder, 1 of robbery. Serious stuff.
And they pleaded not guilty.
Correct. Then the state wanted to introduce confessions they'd apparently made before a magistrate. And the state relied squarely on that presumption, that proviso B, to get them admitted.
Okay. Makes sense for the prosecution. But the defense?
The defense naturally fought back. They argued the confessions weren't admissible. But crucially, they also went bigger. They challenged the constitutionality of Section 217 itself.
Saying this whole reverse onus thing just couldn't fly under the new Constitution.
Precisely. So you get this trial within a trial. The accused testified, saying police beat them, threatened them.
Police denied it, I assume.
Of course. Standard procedure. But Interestingly, the defense called two witnesses, two women, who actually backed up the claims of police assault.
Oh, interesting.
Yeah. So the trial court, Justice Hugo and his assessors, they listened to all this and concluded, okay, we are not satisfied beyond a reasonable doubt that these statements were freely and voluntarily made.
So doubt existed, significant doubt.
Yes. But then, applying the proviso, they also found the accused had failed to discharge the onus on them on a balance of probabilities. They hadn't hit that 51% mark.
So the court doubted the confession was voluntary, but because of the law, they might have had to admit it anyway. What a mess.
Exactly the dilemma. And Justice Hugo saw it clearly. He basically said, the whole case hinges on who has to prove what. He stated, quite frankly, had we been convinced that Section 217 was still valid and constitutional, we would therefore have had little hesitation in accepting that the accused had not discharged the onus.
Wow.
And then he dropped that line you mentioned earlier about the unfortunate result that people who seem to have admitted guilt might be acquitted if the section was struck down, but adding, that may well be the effect of the Constitution. Basically acknowledging the Constitution might force an outcome that felt wrong instinctively, but was legally right.
That really highlights the tension, doesn't it? And we should probably stress here anything the accused said during that trial within a trial about the crime itself. That was only for deciding if the confession was admissible.
Absolutely critical point. It couldn't be used to determine their actual guilt or innocence. The truth of the confession wasn't the issue in that mini-hearing, only whether it was given voluntarily.
So Justice Hugo initially tried to send this whole constitutional question straight up to the top court, right? The Constitutional Court.
He did, yeah. Even though the parties had apparently agreed he could decide it himself.
And how'd that go down?
Not well. The Constitutional Court basically said, no, that referral was wholly incompetent. Trial judges, if they have the power to decide a constitutional point that arises in their case, they have to decide it.
You can't just pass the buck.
Pretty much. You don't just leapfrog to the highest court every time a tricky constitutional issue comes up. The system requires judges at all levels to engage with the Constitution.
Okay, so if that direct referral failed, how did the Constitutional Court end up hearing this major case?
Well, the Attorney General for Natal stepped in and applied for something called direct access to the Constitutional Court.
Direct access. Sounds special.
It is. It's not the normal route. It's reserved for exceptional circumstances.
Right.
Usually, that means serious urgency or major public importance where waiting for the usual appeal process would mess things up badly for the public or the justice system.
And the argument here was?
The AG argued that the uncertainty around Section 272 was causing chaos. Different courts were doing different things, there was inconsistency, and it was prejudicing the administration of justice and potentially loads of accused people.
Because confession admissibility comes up all the time.
Every single day, basically. So the AG said, we need clarity and we need it now.
And the Constitutional Court bought that argument.
They did. They agreed that prolonged uncertainty would be quite unacceptable. So they granted direct access. That's how the validity of this section officially landed before them for a final decision. Game on.
All right, so the stage is set. What was the core constitutional argument against this reverse onus? Where did it clash with the new rights?
The defense lawyers pointed straight at Section 25 of the interim Constitution. That was the chapter outlining the rights of arrested, detained, and accused persons.
Which specific rights?
Several key ones. Section 25(2)(a), the right to be told you can stay silent and what happens if you don't. Section 25(2)(c), crucially, the right not to be compelled to make a confession or admission. Then, Section 25(3)(c), the right to be presumed innocent and to stay silent during the trial. And finally, Section 25, the right to challenge evidence, and importantly, not to be a compellable witness against yourself.
Okay, so a whole bundle of related rights.
Exactly. And what's really interesting, as the court noted, is that these ideas, presumption of innocence, right to silence, no forced confessions, they weren't actually brand new in South African law conceptually.
They've been around
for like 150 years, yeah. But, and this is a big but, they'd often been chipped away at, weakened by various laws or corrupt decisions over the years. The massive change was that the 1994 Constitution didn't just recognize them as principles, it locked them in as fundamental enforceable rights. That created a completely different legal landscape for the Zuma case.
That makes sense. A huge shift in power, really. So how does a court even approach interpreting these brand new, powerful constitutional rights? Is it just like reading any other statute?
Oh, definitely not. The Constitutional Court made that very clear. They looked at how other top courts around the world, particularly Canada, approached it. They embraced what's called a generous interpretation,
Generous, meaning?
meaning you don't read the rights narrowly or legalistically. You interpret them in a way that gives people the fullest possible protection of those rights and freedoms. You look at the purpose behind the right. Why does this right exist? What injustice is it trying to prevent?
Gotcha. Focus on the spirit, not just the letter.
Exactly. And they also specifically warned against cutting down these new constitutional rights just to make them fit neatly with old pre-constitutional common law ideas.
The Constitution comes first.
Unquestionably. And they made another crucial point about Section 25(3), the right to a fair trial. Before 1994, fair trial often just meant following the established procedures. But the court said, post-Constitution, it means something much deeper. Trials now had to align with fundamental notions of basic fairness and justice.
A much higher standard.
A profoundly higher standard. Now, they did add a note of caution. While interpreting rights, you should promote the values of an open, democratic society.
Oh.
But you're still interpreting a written text. The Constitution does not mean whatever we might wish it to mean. You can't just make it up. You have to find the meaning within the words, informed by those democratic values.
Okay, a principled but generous approach. So, armed with that approach, how did they look at these reverse onus clauses more generally? Are they always unconstitutional?
No, not automatically. The court acknowledged they exist in other democracies and aren't necessarily struck down on sight. They looked closely at the U.S. and, again, especially Canada.
What did they take from the U.S.?
The U.S. uses a rational connection test. Basically, does the fact you have to prove rationally connect to the fact that's then presumed? Is it more likely than not? For really serious presumptions, the connection has to be even stronger, like beyond a reasonable doubt.
And Canada. You said that was particularly helpful.
Extremely helpful, mainly because Canada's charter has a limitation clause similar to South Africa's Section 33. This leads to a two-stage analysis. First, does the law violate a right? Second, if yes, can the violation be justified as reasonable in a free and democratic society?
Right, the justification stage.
And they looked at key Canadian cases, like R.V. Oakes, where a law presumed that having drugs meant you intended to traffic them. The Canadian Supreme Court struck that down. Chief Justice Dixon said the presumption of innocence is vital for human dignity and means the state must prove guilt beyond reasonable doubt. If a law could lead to conviction despite a reasonable doubt because the accused failed to disprove something, that's a violation.
Makes sense.
Then there was R.V. White. That case basically said it doesn't matter if the reverse onus is about a core element of the crime or just some side issue. If the accused has to prove anything on a balance of probabilities to avoid conviction, it infringes the presumption of innocence. What matters is the end result.
So it doesn't matter what specific thing you have to disprove.
Nope. If failing to disprove it could lead to conviction despite a reasonable doubt lingering, problematic. This all led the SA Constitutional Court to see a strong parallel. Both Canada's Charter and SA's Section 25 rights were rooted in that golden thread principle from the English case Wilmington. The prosecution always carries the burden of proving guilt beyond reasonable doubt.
The bedrock principle.
The absolute bedrock. So the court felt confident saying, okay, we can appropriately apply these principles worked out by the Canadian Supreme Court to our own situation.
All right, so the big moment. Applying these principles, generous interpretation, focus on purpose, presumption of innocence, the Canadian analysis, how would Section 217 stack up, constitutional or not?
It's not constitutional. The state tried to argue, well, look, admitting a confession isn't the end of the case, or this is just about admissibility rules, not a core element of the crime.
And the court said?
Rejected. Flat out. Why? Because a confession, by its very nature, is usually an admission of all the elements of the crime. It's a full acknowledgement of guilt.
So it's not just some minor procedural point.
Not at all. And here's the absolute crux. If there's no other evidence, and this presumption makes the confession admissible, even though the court has a reasonable doubt about its voluntariness, well, then a conviction could happen because the accused failed to meet that reverse onus.
Even with doubt hanging in the air.
Precisely. That forces the accused to prove something on a balance of probabilities to avoid conviction, which flies directly in the face of being presumed innocent until the state proves guilt beyond reasonable doubt.
So the reverse onus directly undermined the presumption of innocence.
Directly. And the court went further. They said the old common law rule prosecution proves voluntariness wasn't just some random historical quirk. It was an integral and essential part of other fundamental rights, too. The right to remain silent, The right not to be forced to confess, the right not to testify against yourself.
They're all interconnected.
Deeply interconnected. They all reinforce that golden thread. The prosecution must prove its case. Reversing the burden on confessions seriously compromised and undermined all of these rights, making the common law rule part of the fundamental right to a fair trial itself.
Wow. They traced it back historically too, didn't they?
They did, yeah. Briefly touching on how this rule evolved over 300 years in England, specifically to get rid of nasty interrogation methods like those used by the Star Chamber, and how that led to the privilege against self-incrimination. It has deep roots in protecting citizens from state overreach.
Okay, so the court finds Section 217, 1B2 infringes fundamental rights, particularly the presumption of innocence and the broader right to a fair trial. But that's not always the end of the story, is it? There's the limitation clause, Section 33.
Correct. Even if a law infringes a right, the state gets a chance to argue that the infringement is justified. Is it reasonable? Is it justifiable in an open and democratic society based on freedom and equality? Sometimes, is it necessary?
Did the state manage to convince the court that this reverse onus, despite infringing rights, was justifiable?
They tried, but nope. The court found it did not meet the justification criteria. They sort of sidestepped the rational connection test, basically saying, even if it is rational, is undermining a right that's been solid for 150 years really reasonable?
Good question.
And the potential outcome conviction, despite reasonable doubt about voluntariness, they called that a drastic consequence. That weighed heavily. Plus, the state couldn't show it was actually too hard for them to prove voluntariness the old way.
They'd been doing it for ages, right?
For ages, in countless trials. So the argument that it was unduly burdensome just didn't hold water.
So why did they even introduce this reverse onus back in 1970 or 77?
Yeah.
What was the original justification?
It came from a commission, the Botha Commission. Their thinking was twofold. First, to stop accused people from dishonestly taking back confessions they'd genuinely made to a magistrate.
Okay, preventing fake retractions.
And second, efficiency. To considerably shorten and may eliminate those lengthy trials within a trial about admissibility.
Saving court time and resources.
Pretty much. But the Constitutional Court wasn't impressed by these justifications in light of the rights infringement.
How do they counter them?
They said, look, wanting to stop dishonest retractions is fine, but this rule sweeps up potentially innocent people who were actually coerced. It doesn't distinguish. And just because a magistrate thought it was voluntary doesn't justify flipping the entire burden of proof, especially since magistrates weren't even required by law back then to do a deep dive into voluntariness themselves.
Good point.
And as for shortening trials or making life easier for the police and prosecution, the court basically said convenience does not trump fundamental rights of this magnitude. Arguments about convenience might work if, say, the accused clearly has much easier access to the proof than the state, but that wasn't the case here at all.
The state usually has more resources anyway.
Exactly. So weighing everything up, the infringement was serious, the justification was weak, Section 217 was declared inconsistent with the Constitution and therefore invalid. Struck down.
Okay, a huge decision, invalidated. So what did that mean practically? Did it apply backwards to old cases? What was the immediate impact for people, for the legal system?
The retrospectivity question. Always tricky. The Constitution itself had a section 98.6 dealing with this for laws that existed before the Constitution came into effect. Normally, declaring such a law invalid doesn't automatically undo everything done under it in the past.
To avoid chaos, presumably?
Precisely. The court faced a real dilemma. If they made the invalidity fully retrospective, you could have numerous appeals, potentially demands for completely new trials, proceedings de novo, and imagine trying to relitigate whether a confession from years ago was voluntary, witnesses gone, memories faded. It could cause massive dislocation and inconvenience.
A logistical nightmare.
Absolutely. So they had to perform a balancing act. Balance the interests of individuals potentially wrongly convicted under the old rule against the need to avoid chaos in the justice system and ensure a smooth transition from the old legal order to the new. They also acknowledged that police and prosecutors had been relying on this section in good faith, as it was the law at the time.
So what was the compromise? How far back did the ruling go?
They crafted a very specific order. The declaration of invalidity applied to Section 217 in two types of cases. One, any criminal trial that started on or after April 27, 1994, the day the interim constitution kicked in.
Okay.
And 2, where the final verdict had not yet been given by the date of their judgment, which was April 5th, 1995.
So it caught ongoing trials, basically.
Exactly. If your trial started after the Constitution came in and it wasn't finished yet, this ruling applied. Those courts would have to reconsider any confessions admitted under the now invalid presumption. The prosecution would now have to prove voluntariness beyond reasonable doubt.
And the Zuma trial itself?
Directly affected, because the trial court hadn't actually made a final ruling on admissibility yet, waiting for the Constitutional Court's decision. So now the presumption was gone for them too.
Got it. And it's probably important to stress what this judgment didn't do, right? It didn't just wipe out all legal presumption.
Oh, definitely not. That would have been radical. The court was careful to clarify. This ruling didn't affect what are called evidential presumptions. Those are weaker ones where the accused just needs to raise some doubt and not prove the opposite.
A lower bar.
Much lower. And crucially, they acknowledged that some legal presumptions that do reverse the onus of proof might still be justifiable under the limitation clause in certain circumstances.
Like when?
Maybe if the presumption is super rational. Or if the fact is something peculiarly within the accused's knowledge, making it easy for them to disprove but hard for the state to prove. Or perhaps if it's genuinely essential for prosecuting certain kinds of crime where direct evidence is notoriously difficult for the state to get. But, they stressed, this specific presumption about confessions wasn't one of those justifiable ones.
So it was very specific to this context.
Very specific, but the principles were broad. The Zuma case, you see, it wasn't just about striking down one subsection. It was about breathing life into what a fair trial really means under the Constitution. It drew a clear line about how the state has to prove its case, especially when relying on something as powerful and potentially problematic as a confession.
So wrapping this up, what's the big takeaway here? Our deep dive into S.V. Zuma shows us what?
It shows, I think, the immense power of a constitutional court in a new democracy to scrutinize old laws, even seemingly technical ones, against new fundamental values.
Taking the promises of the Constitution seriously.
Exactly. It powerfully reaffirmed those core principles. You're innocent until proven guilty. You have the right to remain silent. The state can't force you to confess. And crucially, the state bears the burden of proving guilt beyond a reasonable doubt. No conviction should stand if there's reasonable doubt about whether the key evidence, the confession, was obtained fairly.
It really solidified those rights in practice.
Absolutely. It became a cornerstone ruling, ensuring fairness was paramount, even if it made prosecutions potentially more difficult in some cases, a landmark for South African justice.
Well, thank you for joining us on this fascinating deep dive into S.V. Zuma and Others, a case that truly did shape the legal landscape in South Africa.
A pleasure. It's a case worth understanding.
It really is, and it leaves us with something to think about, doesn't it? This case shows how even seemingly small procedural rules can have massive implications for fundamental rights. So, here's a thought for you. How does that constant balancing act between the state's genuine need to fight crime effectively and the individual's absolute right to a fair process? How does that require ongoing vigilance and adaptation in any democracy, yours included? Something to chew on.